The new Companies and Allied Matters Act, now seen as Nigeria's most significant business legislation in 3 decades, introduces new provisions that promote the ease of doing business while reducing regulatory hurdles. It's also expected to bring the provisions in line with the technological realities of the 21st century, promoting investments, creating more jobs, as well as a friendly business climate in Nigeria. However, there's been some recent rumblings about certain provisions in the Act which suggest government overreach. Well, we're going to talk about that with my next guest, Augusta Onyenekwe, the head of legal and compliance at Financial Derivatives Company Ltd. Augusta, you're very welcome. Good morning to you. So first, your take on the Act, if you will.
Well, the Act is a welcome development, considering the fact that it's going to be beneficial to several people, several businesses and companies. You will see that there are several benefits to it. And even the present administration, particularly the second tenure of President Buhari, has brought about several reforms. If you look at the petroleum industry bill and also the new minimum wage, even the COVID-19 as it were, you'll see that several reforms have been brought about which will ease doing business in Nigeria, helping investors, and bring about lots of good deeds to Nigeria, and also promote certain things that are really beneficial to companies in Nigeria.
Okay, so can you expand on some of those benefits?
Some of the benefits, as is well, if you look at it, a clear indication, the previous CAMA did not provide for single shareholding structure. So now you have a single shareholding structure as opposed to what was there before. Now people can just set up the company without having to look for someone else. You also have a single director, as opposed to what was there before. So there are several bottlenecks that have been removed and several things that have been brought into place. Also, if you look at it, there's also the take on electronic filing processes. There are several electronic filing processes, even with the documentation, with signing, which is actually very, very, very good, considering the fact that we want to represent with and compete with international practice and international companies and ensure that companies are there. However, we must note that even if these processes have been put in place, we also need to ensure that the risk of the company is also done diligently. We don't just file things electronically without having the risk basis or the risk not set in place. So we need to set those control measures. And now we also have the benefit of having a virtual meeting. So virtual meeting is a welcome development. So from anywhere in the world, you can have the virtual meetings. People can come in and tune in. And it's also less expensive as opposed to what is there, where people will have to hire event centers or hire places. So it's a whole lot good if you look at it.
All right. Now, I do want to ask you about some of these provisions, because there's been, some chatter in the media, on social media and elsewhere, about some of the provisions in the Act. So, for instance, on the matter of liquidation and insolvency, are there any concerns, or rather anything in the Act that would pose a concern to companies that want to look at liquidation and insolvency, and how that would work out with what the Act is providing for?
Yes, I would say there are some concerns if you look at it, because Section 704 of the provision has said that a company can appoint a liquidator or can appoint someone to act as a liquidator or a manager or even a nominee. However, the person must have 5 years post-qualification experience and also be an accountant or a lawyer. But the downside to it is that a certain organization has been put in place so that people can be a member of that organization, and the amount that has been put in place is quite high, considering the fact that you have to register with between 90,000 to 250,000. That might act as a restraint for so many people who might want to act as under the solvency provision.
If one wants to come to the defense of the government with regard to what they've put in there, liquidation and insolvency matters, they seem a bit complex. There's a lot of steps to go through. I don't know. I'm not a lawyer, but I mean, because of that, is that the reason why, if one wanted to argue in favor of the government, that has been put in place, making it that expensive, and the requirements for whoever is going to represent the company to go through that process?
I don't think that process, the mere fact that they mentioned a particular recovery agency, I think it creates a whole lot of ambiguity. I think there should be several bodies that can act, or several bodies that can actually put people through rather than putting just one person. So I won't go with the opinion of the government saying that it should just be just one body. Several bodies or several associations should actually be there to put people through and make people members of that association.
Oh, fantastic. Thank you for clearing that up. So that's particular issue of appointing one company is the biggest sticking point there. Okay. What about the removal of trustees of, help me out here, trustee of an association, section?
The removal of trustee of an association, that's provided under section 839 of the new CAMA, which provides that the commission can suspend, not remove, can suspend the trustee of an association where it's seen that there is a misappropriation or mismanagement from that association. And even at that, it makes provision for suspension. So what people are coming and saying that, oh, it's removal. There's a clear difference between suspension and removal. Although the commission cannot carry out that act without the court order. A court order must be granted from the courts, and it must be done with a petition from the commission, and also with the members of that association, 1/5 of the members of that association, before that suspension is carried out, and before a manager is brought in to manage the affairs of that association.
Okay, great. So with what you've just added now, the court order, the petition, and so on and so forth, that wasn't explicitly put forward in Section 839, was it?
Yes.
Okay,
so now you have the only part people keep saying is the Section 839. But if you read further, you will see that the provision of having a court order has been put in place. So people are only saying, the commission can suspend the trustees of that association, without realizing that before that is carried out, there must be a court order to that effect.
Okay, so in that case, should that, I guess, because some folks have been talking about that particular section, are you saying then that it's the reaction is overblown? And if I
think it's overblown, and I think for better understanding, it's always good to read provisions in full rather than reading it in parts, so that you have a better understanding and you get clarity over the provision.
And also speak to legal folks like yourself. Also.
Exactly, you get a lawyer to do it.
Okay, so that means if there's one section here that really bothers you, then I guess we're still going back to Section 704. That appointment of that one company to do the insolvency and liquidation. That's the main one for you.
There are several provisions. There are several provisions, but those two kind of strike out because that's what people have focused on over the past couple of days, because of the main company that was appointed, because the company is actually a private company limited by guarantee. So there are several ticks to it as to why should that company be appointed. But if you look at it, I think it's something that can be reviewed, and there are better ways of doing it so that there is unity and there's transparency, so that investors as well can invest in Nigeria freely and make Nigeria to be that capital, attractive capital we've always wanted. Great stuff. Okay, we've only got about a minute left. What else can Nigerians, SMEs, business owners look forward to with regards to the other provisions? Oh, there's several. If you look at it, you know, there's no longer, what we have now is the minimum issued share capital as opposed to the authorized share capital. You pay for what you need now. You don't need to have that authorized share capital. And even at that, so many small companies no longer need a company secretary. They no longer need an auditor. However, even if they do not need a company secretary and auditor, they still need the services of a legal practitioner or a practitioner who is quite vast in knowledge in that sector, so that they don't end up making errors or having issues, who can advise them over the regulatory provisions, over the governance provisions, to ensure that there's accountability and things are well done properly. Fantastic stuff. Great to have you here. Augusta Onyenekwe, Head of Legal and Compliance at Financial Derivatives Company. Thank you so much for taking us through the CAMA Act. We appreciate your insights. Thank you so much.